So welcome to this session where we'll be starting on the current affairs that are projected to be asked during the oral sessions. So because tomorrow is a Monday on 25th, we expect the finance bill to be enacted into law, into an act. But before it reaches its way up to the act, we will like to have a brief overview of the changes that the bill is proposing to amend or introduce into the tax regime. So briefly before you, I'll give credit to AfriWise for posting this information to be used for academic purposes. So the bill proposes the following: that it seeks to amend the definition of management and professional fees to include interchange fees and merchant service fees arising from card-based payment transactions. So this amendment arises from the landmark decision of Barclays Bank, where the issue on interchange fees and merchant service fees was considered to form part of one of the sources of withholding tax in Kenya, and now we can see this bill trying to implement this by incorporating it into an act. The second proposal is to amend the definition of royalties to include payments relating to proprietary digital platforms, payment networks, and software distribution arrangements. Then we have subject to non-resident rental income to final withholding tax and to increase the residential rental income tax rate from 7.5 to 10%. So this is the proposed increment that people are saying that it will cause a direct impact to rental amount in various places. And the most saddening thing is that the cost of living is going up, but the salary is stagnant. Then we have another introduction to say 5% tax on customs value of imported second-hand clothing and footwear as part of measures aimed at expanding the tax base. This is on mitumba clothes. Then to broaden the taxation framework applicable to insurance companies by shifting the basis of taxation from life insurance businesses to statutory funds in line with the Insurance Act. So if you are well aware is that when it comes to insurance compensation monies, the same had been exempted from VAT, but we can see the Finance Act trying to slowly bring the Insurance Act provisions into the tax bracket this year. Then to revise the timelines for filing income tax returns by requiring submission by the last day of the fourth month following the end of the year of the income, while requiring nil returns to be filed within 1 month after the end of the relevant year of income. This touches on the Tax Procedures Act, and it basically reduces the timelines where a person is required now to file the same within a shorter period of time. Then to exempt pension benefits arising from death from income tax. Then to introduce enhanced reporting obligations for virtual asset service providers and facilitate the international exchange of digital asset information. This is the provision that will also affect cryptocurrency traders, where they will be required to reveal and share their historical trading patterns, so that the KRA can evaluate their income tax. So when you talk on virtual asset service providers, this is a new area that is also being governed by the capital markets. This year it's a new market to venture into. So that is it when it comes to taxations. Then we have to amend the VAT framework by requiring reversal of input VAT attributable to unsold supplies that subsequently become exempt, and by extending the VAT refund claim period to 3 years. So that is also an amendment to capture a change when it comes to tax procedures. Then to increase the duty-free thresholds for travelers from 300 USD to 2000 USD, thereby easing the tax burden on qualifying personal imports. Then we have to expand exempt supplies while removing various items from zero rating, particularly in the agriculture sector, energy, manufacturing sectors, including imported mobile phones, motorcycles, electric bicycles and buses, solar products, and lithium-ion batteries. So this act will seek, this bill, as per today, seeks to expand exempted supplies while removing various items that were previously under the zero rating category to be to fall under the tax brackets proposed by this bill. So the other additional point is that to expand the scope of excise duty by introducing a 50% excise duty on antique and vintage motor vehicles, increase excise duty on telephones to 25%, and shifting the tax point for telephones to activation. So this is another angle where people are saying that if you check the historical aspect of charging excise duty is known as a sin tax. This is usually taxed on activities or products where the government is trying to control the morality, in quotes, of the public, e.g. tobacco use, beer use, and alcohol consumption or gambling. But when you introduce 25% to mobile phones, we expect a surge, an upward surge when it comes to the prices of smartphones, because it is not appearing to be a deterrent when it comes to the mobile use in Kenya, but we are trying to shift the republic to go to the analog route. And then we also have to amend the provisions restricting the commissioner from issuing agency notices where a taxpayer has appealed against an assessment. This is also a major blow because it seeks to amend the Tax Procedures Act and to add provisions that were restricting the commissioner from issuing agency notices where a taxpayer has appealed against an assessment. That will be a blow to numerous taxpayers in Kenya. Then, two exempt transfers relating to real estate investment trust rates are from stamp duty. So basically, this is a win for the people involved in real estate investment trusts in Kenya, because they will be exempted from the payment of tax duty. So those people who are asking themselves what the real estate investment trust as an investment alternative to limited liabilities companies in Kenya is, I did together with, in collaboration with another author, we discussed the following when it comes to the rate system. That basically you just have to know the key determinants, because it can also come under the conveyancing paper as a new tool where people are trading in real estate investments. So a real estate investment trust REIT is a regulated collective investment vehicle that owns, operates, and invests in a real estate asset by pooling funds from a group of investors. So REITs allows investors in Kenya to invest indirectly in real estate assets such as office buildings, shopping centers, hotels, and residential properties. The REIT leases out the property under its ownership to collect rent, generate income for the investors, and drive asset appreciation in the longer term as rent increases. So the rental income earned is then distributed as dividends to REIT investors. So presently in Kenya, as of 2024, by the time I was doing this paper, there were only 4 authorized REITs in Kenya to operate, where we have Ilam Fahari IREIT, we have Akon Student Accommodation IREIT, and Akon Student Accommodation DREIT, and LAP Trust Imara IREIT. If you have followed the recent developments when it comes to this Kwetu and Kejani apartments, and the model that they have used in securing funding from abroad, they have developed what we call D rates and I rates. So in a brief angle, before we go back to the current affairs arising, you realize that, however, ILAM, Fahari iRate, the only one that was actively trading on the Nairobi Stock Exchange, was delisted on 12th February 2024. So ILAM Fahari iRate left the market. On the other hand, Akon Holdings, both iRate and D-Rate, secured 180 million in an equivalent of 23.6 billion Kenya shillings in funding from the US Development Finance Corporation for affordable student housing, and the financing will be repaid over a period of 18 years and shall provide a long-term and sustainable financing solution for the Akon rate investment tool. So the Capital Markets Authority in Kenya is responsible for governing and regulating the rates systems. The CMA established a comprehensive framework and regulations for the rates in 2013 as a return ensuring transparency, accountability, and investor protection within the sector. Rates are established and governed by the following regulatory frameworks in Kenya, but I'll not delve into the exact sections because this paper was very lengthy. So they are four in number. We have the capital markets, real estate investment trusts, and collective investment schemes regulations of 2013, and we have the Capital Markets Act 485A, and we have Capital Markets Corporate Governance on Market Intermediaries regulations of 2011, and we have the Income Tax on rates rules 2020. Now the proposed finance bill targets to remove the rates investment trust from the payment of stamp duty. So from that angle, we can say that we have now fully understood what, in a brief manner, what the proposed finance bill is coming to change and what is coming to be amended. So for purposes of today's discussion, I had also prepared a document that I'll also share so that we have a look at it in a few. So here it is. Yes. So before you have our session 1 on current affairs being orals, and the first oral question that we can predict for this year is when you'll be asked to explain how the AI in the legal field in Kenya is going to be regulated or its use in Kenya currently. So of late, we have decided to incorporate two UK decisions known as Ayinde versus London Borough of Haringey and Al Harun versus Qatar National Bank, where they have revealed the dangers of mishandling of AI tools for case preparations and legal guidance. And in both cases, the advocates used AI to the detriment of their case, whereby in the former, the court found that they had met the threshold for initiating contempt proceedings by deliberately including a fake citation in their submissions. In the latter case, the solicitor relied on AI-generated research done by the client without verifying, and the court held that they cannot delegate their professional work to AI. In Kenya, we have also seen a Court of Appeal decision that cited a statute that is not existent in our Kenyan laws. So this prompted the judiciary, pursuant to a meeting or an engagement between the Supreme Court of Kenya and the Federation of the Supreme Court of Ethiopia on 11th August 2025, where the CJ stated that no one will be left behind in the digital shift, and they are currently establishing ICT help desks within Huduma centers and court stations so as to ensure that users navigate online services and e-filing systems. Then we have seen recently where the judiciary has circulated, but in quotes, I'm not sure whether the same as emanated from the judiciary. There is a current development of a policy framework for the adoption of AI in our courts, and this framework is developed to manage and monitor AI adoption in Kenyan courts and tribunals by ensuring that it is aligned with the Constitution and champions a people-centered approach to dispute resolution by expanding access to justice and fostering social harmony. So before I decided to have a look at the same in a brief manner so that everyone can understand. These are the practice directions on the use of artificial intelligence in courts, being the draft documents. So what you need to know is that they apply to all Kenyan courts and tribunals, and they permit AI use, but AI must not replace an advocate's professional judgment or a judge's independent decision making. Then another key takeaway is that user responsibility. Anyone using AI will have to cover for will be fully responsible for the accuracy, completeness, integrity, and candor of their documents. Then mandatory disclosure. If AI assisted with any filed document, these practice directions have made it mandatory for people, including the advocates, to annex that disclosure document after they have filed their pleadings. So non-disclosure may affect cost and is treated as a candor breach. Then we have citations and research control. All AI-assisted legal research and citations must be independently verified against authoritative sources. Fictitious or materially inaccurate citations will trigger immediate notice to court and corrective filing, and the court may refuse to consider unverified authorities. Then another key takeaway, we have drafting limits, where they say that there will be no copy pasting of AI output, and the output must be meaningfully reviewed and revised. Whether it is an affidavit, witness statement, this must reflect the true personal knowledge of that person, and no fabrication will be allowed. Then AI as evidence. AI-generated outputs may be produced as evidence only with a prior notice, and you need to annex a person to the one of the templates that has been provided in the practice directions document. Then we have judicial use controls, where judges may use approved AI tools for administrative or research support, but cannot delegate reasoning or discretion to the AI-assisted tools. Then we have data protection and confidentiality. The practice rules state that a person should comply with the Data Protection Act and confidentiality and privilege duties, and you should avoid uploading personal or privileged or sensitive data without a lawful basis to these tools. Then sanctions. Court may strike out or award personal cost and can refer any advocate to the LSK or disciplinary bodies, and or invoke contempt powers for breaches. So this can also have an effect to the Advocates Act, and the same can also be amended to include new misconduct and professional negligence arising from AI. Then review cycle. Directions to be reviewed at least every 12 months due to rapid AI changes. So the judiciary is aware that AI is here to stay and is moving quickly with time. But on the other hand, we have seen a critique on the same proposed practice directions, and let us hear, because you can be asked during the panel interviews to critique the practice directions that have been released by the judiciary. So overall thesis that the draft AI practice directions are framed as accountability rules, but are criticized as reactionary, impractical, technologically uninformed, and constitutionally or statutory suspect, creating fear and bureaucracy rather than responsible innovation. Then we have another point where technological illiteracy claim. Drafters allegedly assume AI produces ready-to-file work, ignoring real workflows where AI is used mainly for brainstorming, skeleton drafting, formatting, summarizing, refining language, research assistance, transcription, organization, templates, and issue spotting, all requiring heavy human review. Then you have disclosure seen as redundant or discriminatory. Since advocates already bear full professional responsibility, mandatory AI disclosure is criticized as performative and a double standard, especially because many everyday tools, e.g. Word, Grammarly, research databases, email, predictive test, embed AI. Then constitutional objection. Article 159. Mandatory disclosure is said to create new procedural technicalities that can trigger sanctions despite meritorious pleadings, allegedly violating the command to avoid undue regard to technicalities. Then you have civil procedure objection under Order 2, Rule 14, where the critic argues that pleadings should stand on merit and sufficiently not be jeopardized by failure to disclose use of tools like Grammarly, ChatGPT, turning practice into a procedural minefield. Then ultra-vires argument, where we have the practice directions are said to be subordinate administrative instruments and cannot lawfully create new quasi-disciplinary regimes or consequences like striking out or issuing personal cost and referral or evidentiary exclusion without a statutory backing. Then you have policy inconsistency. A draft is criticized as conflicting with Kenya's tech-forward national agenda, where we have the digital economy, e-government, court digitization, by stigmatizing AI and chilling adoption, even after Kenya being ranked as number one in the global sector for the use of AI in the world. Then we have economic unfairness, where we have compliance burdens are said to disproportionately hurt young advocates and solo law firms who use AI to offset lack of clerks, researchers, and to keep services affordable. Then we have mischaracterizations of AI generated. The critic continues to say that AI does not reason or strategize. Lawyers still do the legal work, uh, take instructions, verifications of the instructions, they restructure their position, they enable courts to write sound judgment through submissions, they tailor their work to human enabled work. So labeling work as AI generated misstates authorship. Then we have enforceability problem, where we have humanizer tools. Disclosure regime is called unenforceable because paraphrasing and humanizer tools can remove detectable AI traces, leading to selective enforcement and incentivizing concealment. Then we have privacy and strategy risk. Requiring disclosure of tools or models or purposes is portrayed as compelled revelation of internal workflow and litigation strategy, unlike any requirement to disclose research assist, typist, textbooks, or search engines. Then we have punitive tone critique, where emphasis on sanctions on contempt and referrals and strikeout is said to promote fear over guidance, undermining responsible adoption. Then we have internal inconsistency, where the draft allegedly admits AI is inevitable and advocates remain responsible, yet still imposes exceptional AI-specific disclosure seen as logical inconsistent. Then lastly, we have proposed alternative, where the practice directions drop AI specific disclosure and force the exist baseline rule, where advocates are responsible for what they file and focus on education, verification, cybersecurity, ethics, and access to justice. So the critic is, on the other hand, is telling the framers of those practice direction in that they should drop the AI specific disclosure route. They should focus on education, verification, cybersecurity, ethics, and access to justice. How can judiciary incorporate AI to reduce the backlog in their stations? That is the angle that the judiciary should take, not to come gun blazing over people who have decided to go virtual. Then we have still some decisions that were made this year that are very landmark. We have the adolescent consensual relationships decision that was passed in May 2026 in a historic constitutional ruling in petition E490 of 2025. The High Court has declared that the blanket criminalization of consensual adolescent relationships under the Sexual Offences Act infringes on constitutional rights to privacy, health, and dignity. It ordered the Director of Public Prosecutions to gazette prosecutorial guidelines to prevent the arbitrary arrest and prosecution of adolescents. Then you have the Supreme Court reverses ban on Ahmed Nasir Abdullahi ban that was imposed by the Supreme Court. So in a major procedural decision in Attorney General versus Guruman Limited, the Supreme Court lifted a high-profile 2-year ban it had placed on senior counsel Ahmed Nasir Abdullahi from appearing before the Apex Court, then thus bringing a closure to a heavily debated professional restriction. Then we have Digital Rights and Cyber Harassment 2026, where the Court of Appeal scheduled a highly anticipated judgment for February 27, 2026 regarding a petition by Bloggers Association of Kenya that challenges provisions on cyber harassment and false information, which they argued violated free speech protections. And we duly saw that Section 26 thereabouts of the Computer Misuse and Cybercrime Act was declared unconstitutional for being too vague. And then we have Conflict of Interest Act 2025. This was operationalized in August 2025, where this act now repealed the Public Officer Ethics Act to provide a consolidated statutory framework governing conflict of interest within the public sector, fundamentally altering how public officials and their legal counsels navigate compliance and ethics. Then another key point to focus is that this year we had a webinar that was convened by the Kenya School of Law, CLE, and other stakeholders on lawyers rethinking the flooding of the legal profession debate, where the key point is to unlock untapped legal markets. So basically, we can analyze the limitations of traditional legal training. So Kenyan law schools predominantly emphasize litigation skills, commercial law, and conveyancing practices. This curriculum produces graduates who overwhelmingly aspire to courtroom advocacy or routine transactional work. The result is predictable: fierce rivalry for court appearances, briefs, and standard corporate deals. While these areas remain vital, they represent only a fraction of the legal professional's potential. This mismatch between training and market diversity perpetuates the myth of oversupply. Okay. Well, then we have policy and legislative development opportunities. One of the most promising yet underutilized areas is policy and legislative design. Lawyers possess unique skills to craft national policies and legislation across critical sectors of the economy. Energy policy, agricultural law, and regional integration frameworks all demand legal expertise to create practical, enforceable regulations. Government agencies, think tanks, and international organizations frequently seek lawyers for legislative drafting and policy analysis, yet few practitioners pursue these intellectually rewarding and impactful careers. Then we have emerging frontiers in climate and green finance, where the global and national push towards sustainability opens another frontier: climate change law and green finance. So Kenya's commitments under the Paris Agreement and national climate strategies will require lawyers to advise on green contracts, carbon trading mechanisms, and environmental compliance and sustainable investment frameworks. As business transition to low carbon models, demand grows for legal guidance on ESG, where we have environmental, social, and governance systems, reporting, and climate risk management. This specialized niche offers lucrative opportunities for forward-thinking lawyers. Then we have technology, data protection, and innovation law, where we have rapid technological advancement creates urgent needs in science, technology, and innovation law. Data protection legislation, cybersecurity frameworks, artificial intelligence governance, and digital economy regulations require sophisticated legal input. Kenya's Data Protection Act and emerging digital policies present a burgeoning field where lawyers can shape legislation. They can also advise tech startups and represent clients in privacy disputes. Currently, this area suffers from a severe shortage of specialized practitioners, and this gap is being utilized by the Finance Bill of 2026, where it is proposing to see various M-Pesa transactions of an individual, where they will be linking M-Pesa transactions to tax payment portals. So if you can see now the bridge that is going to be formed there, we have a data protection on this side, then we have a tax compliance on the other side. To what extent can data protection apply? So these are the critical angles where the webinar wanted to also bring into the attention of the participants. Then you have intellectual property and corporate growth sectors, where the IP practice represents another underexploited opportunity as Kenya's creative industries, technology sector, and innovation ecosystem expand. IP protection becomes essential, and lawyers can assist artists, investors, and businesses in securing trademarks, patents, and copyrights while enforcing rights against infringements. Then we have reforming legal education for market relevance. Addressing this disconnect demands curriculum reform. Law schools must integrate practical training in policy analysis, environmental law, technology law like ZTech School of Law, IP management, and corporate advisory services, while Chuka University School of Law focuses on environmental law. Professional bodies like the LSK should champion continuous education programs exposing practitioners to those diverse fields. Then, what other key takeaway do you should you have at your fingertips? You should have the National Assembly Gazettement of the Law of Contract Amendment Bill of 2025, where the Kenya's Parliament has received the Law of Contract Amendment Bill 2025 that has been sponsored by Wajir East MP Aden Dawood Mohammed, dated 10th April 2025, where the main key takeaway from this bill is that it seeks to introduce several key protections, including a prohibition against contractual terms to exclude liability for death or negligence, and any attempt to limit liability for loss or damage from negligence must now meet a requirement of reasonableness. So this will require a deeper analysis, because the bill also codifies negligence, which had long been recognized under common law, into statute, thereby effectively creating a statutory cause of action for contractual and negligence. And the bill also provides that in supply contracts for goods intended for consumer use, for business to consumer agreements, suppliers are barred from excluding liability for breach, delivering substantially different performance than expected, or rendering no performance at all. Then lastly, we have the protective provisions of the bill also apply to sale of goods and hire purchase agreements. While consumers enjoy absolute protection under those arrangements, parties contracting in a non-consumer capacity retain some degree of flexibility to exclude or restrict liability, provided the relevant contractual terms meet the established reasonableness standard. So basically, the reasonableness standard appears to be the new amendment, or rather a new area to be cemented in our Kenyan laws. Then we have another angle that is arising when it comes to the deals dominance and public interest sector. We have the evolving shape of merger control in Kenya's financial services sector. So basically, you must understand the Kenyan merger control regime is established under the Competition Act Cap 504 and supplemented by subsidiary legislation and guidance. Requires certain transactions to be notified to and approved by the Competition Authority of Kenya prior to implementation. That framework reflects a conventional model of pre-merger review. Now, in substance, this is where the difference lies. In substance, however, the analysis is not confined to competition. The authority applies two distinct though interconnected inquiries. The first considers whether the transaction is likely to result in a substantial lessening of competition, and the second limb addresses whether the transaction gives rise to public interest concerns. So both limbs are embedded in the statutory framework. What is evolving is how they are applied. The competition analysis focuses on the market structure, including concentration, market power, and competitive constraint, while the public interest inquiry introduces a broader set of considerations, including employment, access to services, and wider economic policy. So basically, that. I've lost my connection. Oh, sorry, I had lost my connection. So basically, the key takeaway from the evolving shape of merger control in Kenya is actively being observed in the Vodacom sale of shares, Vodacom purchase of Safaricom shares, where Vodacom is trying to have the upper hand when it comes to the merger sector. So this is why we are invoking the public interest inquiries, and we have a court freezing the Treasury's 244.5 billion Safaricom deal as battle over state stake deepens, where in May 19th, 2026, the High Court has extended orders blocking the Kenyan government from proceeding with the controversial sale of a 15% stake in Safaricom to South Africa's Vodacom Group, delaying what would have been a massive 244.5 billion payout to the Treasury. The ruling now throws one of the Kenya's largest corporate transactions into fresh uncertainty, even as the government faces growing pressure to finance infrastructure projects, manage debt obligations, and plug debt deficits. A three-judge bench ruled that the transaction should remain frozen until constitutional petitions challenging the legality of the sale. I wanted to confirm that my device was still recording. A three-judge bench ruled that the transaction should remain frozen until constitutional petitions challenging the legality of the sale are fully determined. Consequently, we do not buy into the argument that a constitutional adjudication automatically results in loss of confidence by the investors. By this, the judges are addressing the risk that the investor can decide to withdraw the deal automatically pursuant to the delays that we are experiencing in our courts. Such an argument, if accepted by this court, will lead to immunity from judicial review for public dealings because those dealings are economically motivated. So the court has stood by its ground to say that you cannot force the courts to fast track a certain deal because of economical pressures that are currently facing the country. So that is a complete exercise of judicial independence. The Treasury has gone ahead to say that the Treasury had expected to receive 204.3 billion from the sale itself and an additional 40.2 billion in advance dividend payments tied to the government's remaining 20% stake in Safaricom. Under the deal, Vodacom would acquire the government's 15% stake at 34 shillings per share, while also buying an additional 5% stake from Vodafone Group. Once completed, Vodacom's ownership in Safaricom will rise to 55%, effectively giving the South African telecom giant majority control of the Kenya's most profitable company. The transaction was challenged in court by petitioners including Tony Gashoka and Frederick Ogola, who questioned the legality, transparency, and broader public interest implications of reducing the state's ownership in Safaricom. Critics argue that Safaricom is not just another listed company, but a strategic national asset deeply intertwined with Kenya's financial system through M-Pesa, digital payments, data infrastructure, and telecommunications. And this is the angle that I've told you that it is a test to the public interest control, in as much as we have the market controls checker in place, but will it meet the public interest threshold? Remember, with the finance bill of 2026, what is coming to reveal to Kenyans is that the KRA will have our transactional data. Now this company is coming to buy Safaricom, and it is the majority shareholder of this company. So in essence, majority of the Kenyans data can also be exposed to South African territorial jurisdiction. So basically, concerns have also been raised over whether the government is getting full value from the transaction, especially considering Safaricom's improving profitability and rising share price every year. Earlier this year, Safaricom shares rallied to 34 shillings on the Nairobi Securities Exchange, matching the Treasury's agreed sale price and strengthening debate over whether the state should sell a highly profitable asset at a time when the company is posting record earnings. Some critics have additionally questioned whether the sale could weaken Kenya's strategic influence over critical digital and financial infrastructure in the long term. Online discussions around the transaction have reflected growing public skepticism. On Reddit, some users argued the deal risked handing over excessive control of a strategic Kenyan company to foreign interests, with one commenter describing the transaction as a quiet state capture of one of the nation's most strategic assets. other question the timing of the sale. Given Safaricom's strong financial rebound and rising dividends, the Treasury has consistently defended the transaction, arguing that proceeds from the sale will finance large-scale infrastructure development through the newly established National Infrastructure Fund. Then, lastly, Treasury Cabinet Secretary John Bandi previously said the fund would help finance commercially viable infrastructure projects including roads, railways, water systems, and energy expansion. So that is it. Then another area that is also arising is where the High Court deals with the question of time-barred claims in respect of trademark expungement proceedings. Before you, we have a case Thamos Hong Kong Limited and another versus Doshi Ironmongers Limited 2025, where the defendants filed a counterclaim seeking the expungement of Thamos Hong Kong's trademark in respect of the well-known and internationally recognized Thamos trademark on the ground that there was no valid assignment. Thamos Hong Kong contended that its well-known marks were registered in Kenya in 1920 and 1975 and their assignments recorded in its favor in 2011. The court's finding, for clarity, are that the High Court held that Section 16(1) of the Trademarks Act establishes clear time limits for challenging the registration or assignment of a trademark. Under the Act, a trademark registration becomes conclusive as to its validity after 7 years, unless it was obtained by fraud or contravenes Section 14 on deceptiveness. The court ruled in favor of the plaintiffs by finding that no fraud had been proved by the defendant, and therefore the exception to the limitation period under Section 16 did not apply. It emphasized that statutory time limits are not mere procedural formalities but serve to promote certainty, stability, and finality in transactions involving proprietary rights recorded in the trademarks register. It further ruled that allowing previously settled registrations, particularly those uncontested for over a decade, to be reopened without lawful cause would undermine predictability, create insecurity around registered rights, and discourage investments in branding, and lastly, weaken the integrity of the registrar as a definite record of IP rights. Then I also decided to go under the highlights from the Kenya Gazette, that was posted in 8th May 2026. And briefly, we have presidential appointments, where the President William Samoei Ruto appointed Dr. Julius Murori Benjiwe as an ambassador within Kenya's foreign service. The president also appointed Dr. Kefa Nyamoya Omai as the chairperson of the National Cohesion and Integration Commission for a 6-year term, and additionally, 7 new members were appointed to the NICIC board, including Josephine Kirion Eragai, Joseph K. Nguyo, Jackson Swadi, Dr. Samuel Mwarucho Mwawasi, Irene Tulel, Hassan Bilo, and Jerusa Mwatime Michael. These appointments come at a time when conversations around national unity, ethnic relations, political tolerance, and hate speech continue to dominate public discourse in Kenya. That is a potential question during our oral examinations. And we have also seen another Gazette notice saying that judiciary issues new guidelines on road accident claims. One of the most significant legal updates in this Gazette was the judiciary's new guidelines on the transfer of personal injury claims arising from road accidents from small claims courts to magistrate courts. The guidelines follow a January 2026 High Court decision, Gadhaia versus Attorney General and others, where the court directed that pending road traffic injury claims before the small claims be transferred to the magistrate court. So key takeaways that you must know is that only cases that had not been concluded by 22nd January 2026 will be transferred. Then existing judgments already delivered by the small claims court will remain valid. Then transferred matters will retain their original records for traceability, and then the judiciary directed that all transferred matters be handled on a priority basis to avoid delays. For litigants, lawyers, insurance, and victims of road accidents, this is a major procedural development that could significantly affect timelines and handling of compensation claims. Another key takeaway from the Gazette in Kenya, we have the JKIA Magistrate Court being moved under Kibera High Court supervision. So the Chief Justice Martha Koome also gazetted a restructuring of court supervision jurisdiction within Nairobi County, where the JKIA Airport Magistrate Court will now fall under the supervisory jurisdiction of the Kibera High Court with effect from 4th May 2026. This notice also recognized how several Nairobi Magistrate Court are supervised administratively by different High Court divisions. Then we have CBK licenses more digital lenders. So the CBK has licensed additional 32 digital credit providers, continuing its crackdown on unregulated money lending practice in Kenya. Some of the newly licensed lenders include Kopo, Izwe Loans, Haki Africa, Karibu Credit, Komoko Capital Kenya Limited, Jawabu Biashara Limited, Yehu Impact Limited. The licensing framework is part of the CBK's ongoing efforts to regulate Kenya's rapidly growing digital lending space. Then we have also seen some land notices continuing to dominate the Gazette sector. As is commonly with many Gazette editions, land-related notices occupied a large section of the publication. The Gazette carried numerous notices on lost title deeds, replacement of title deeds, provisional certificates, and new land title deeds and revocation of provisional certificates. One notable notice involved the revocation of a provision title relating to land in Mombasa after allegations of misrepresentation and concealment of ownership details. These notices are particularly important for property owners, buyers, advocates, banks, and anyone conducting land due diligence. So I saw it fit because you can be asked on various procedural steps that arise from various Gazette notice procedures I saw it fit for us to have a look. So briefly, if you have lost a title deed, what will you do immediately? You confirm registration details, do an official search at the relevant land registry and confirm if any charge or encumbrance exists. Then to report the loss, obtain a police abstract, commonly registry requirement in practice through those section 33 focuses on evidence. Then 3, prepare evidence pack documents where you have the copy of the ID, KRA PIN, incorporation documents, the search that you did, the police abstract that you have obtained, and any chargee consent if the land is charged. Then 4, prepare statutory declarations. You must have a look at section 33(2) of the LRA by all registered proprietors for a company, by a director, and by the chargee if the land is charged. Then file application to the land registrar for replacement pursuant to section 33(1) of the LRA and pay prescribed fees. Then how do you replace a title? Replacement certificate of title under section 33, the procedure continues. The land registrar reviews evidence and may call for further inquiry or verification. Registrar will publish a notice of intended replacement in the Kenya Gazette and 2 nationwide newspapers. So as I duly found one of the replacement Gazette in the Kenya Gazette portal, then I lifted the same. This is where the registrar will publish the intended replacement in the Kenya Gazette and 2 nationwide newspapers pursuant to section 33(3) of the LRA. Then you have to wait for 60 days from the Gazette or publication trigger in section 33(3). If no successful objection or adverse claim will arise and registrar remains satisfied, registrar will issue the replacement certificate. If the old certificate is later found, you need to surrender it to the registrar for cancellation. This is pursuant to section 33(4) and it must not be used again pursuant to section 33(6). So I've had a person lifting up their hand. You can just unmute because I'm not in a position to view the screen. So the other key takeaway from the Gazette notice is that we have provisional certificates. These are practically temporary or duplicate instruments pending replacements. So same trigger as the application procedure above. The registrar will, with statutory declarations and evidence, you will have to do the same. They will have to do the same gazettement procedure under the Gazette plus 2 newspapers of national circulation and 60 days waiting period. Then registrar issues the provisional or replacement instrument once satisfied. Courts treat this as an administrative power that must follow section 33. Any filings thereafter should be based on the validly issued instrument. The old one is unusable. So new land title deeds. Situations where you can be given new land title deeds. It is one on transfer, where we have sale, where it is a gift or it is a transmission. You lodge the registrable instrument, whether it is the transfer or the transmission. You lodge the consents, the rates or rent clearances and stamp duty documents, then produce existing title for cancellation unless the registrar dispenses with production, and then registrar registers the disposition and issues a new title in the new proprietor's name. Then after adjudication, first registration and subdivision, this is also another point where you can be issued with another title, with another new title, complete adjudication and subdivision approvals and surveys, then lodge the mutation forms and approvals. Registrar will open, they will update the register and issue new titles for resultant parcels. Then another thing that you have to take note is revocation of provisional certificates. Remember, the registrar had issued the provisional certificates as this person who had lost their title was waiting for a new title. So how have courts even interpreted this part? So identify the basis, e.g. provisional or replacement issued without loss, without declarations, without gazettement or notice or fraud or procedural unfairness. Under what basis do you want to revoke the provision certificate? Then write to the land registrar, request or recall or cancellation and supply proof where you have the searches, original title or correspondences, etc. If administrative correction is refused or ignored, you will move to the court for judicial review, statutory or mandamus orders to quash and compel cancellation where the process or jurisdiction was defective, as in the case below. This is the case of Republic versus Chief Land Registrar and others, 2015 decision, where the ratio decidenda is that the court found that the Chief Land Registrar and Registrar of Titles acted without jurisdiction and in breach of statutory and constitutional requirements by issuing provisional certificates of title when the originals were not lost and the applicants had notified them of this fact. The respondents failed to make adequate inquiries or consider the applicants' representations as required by Section 33 of the Land Registration Act. The absence of a response from the first and second respondents further indicated a lack of procedural fairness. The decision to issue provisional titles was therefore ultra vires, procedurally improper and in violation of the applicant's right to fair administrative action under Article 47 of the Constitution. The court emphasized that its role in judicial review is scrutinize the process, not the merits, and found that the process here was fundamentally flawed, warranting the quashing of the impugned decision. Then after revocation or cancellation, the registry will update the register and where appropriate reinstate the correct position. Any subsequent dealings based on invalid provisional title may also be attacked depending on facts. That is it when it comes to the assessment of the Gazette notice that was made on 8th May in relation to lands. Then I also found a post on insolvency and company notices. So the Gazette also carried several insolvency and company related notices, including appointment of liquidators, intended company dissolutions, and corporate compliance notices. These notices are closely monitored by creditors, investors, suppliers, and legal practitioners, as they often signal financial distress, restructuring, or winding up processes. So I saw it vital for us to understand what each notice entails and how the same makes itself to the Gazette part. So we start with the appointment of liquidators in Kenya. When it comes to appointment of liquidators in Kenya, we have 3 steps of appointment of liquidators. We start with members voluntary liquidation. This is the solvent wind down procedure, where number 1, the directors or members, they decide on member voluntary liquidation route. They convene a general meeting. Okay, so the company passes the required resolution for voluntary liquidation through the board and company approvals per the Constitution and Insolvency Act procedures. Then in the same or a subsequent general meeting, members appoint an authorized insolvency practitioner as a liquidator. This is pursuant to Section 399 of the Insolvency Act. Then upon appointment, directors' powers will cease except as sanction. This is pursuant to Section 399(2). So that is one avenue of appointing a liquidator through the members' voluntary liquidation. Then the other route is using the creditor's voluntary liquidation pathway. The company resolves to voluntarily liquidate, convene a required creditors meeting under the creditors voluntary liquidation framework. Then number 2, company meeting nominates an authorized insolvency practitioner. Then the creditors meeting nominates an authorized insolvency practitioner. Creditors nominee generally prevails in this situation. This is pursuant to section 408 1 to 2. 4. If company and creditors nominate different persons, any director or member or creditor may apply to court within 7 days to resolve and appoint. This is pursuant to section 408 3 to 4 of the Insolvency Act. Then creditors may also constitute a liquidation committee. This is optional for guidance, for governance and oversight of the whole procedure. That is another angle of appointment of liquidators. Then lastly, we have court liquidation pathway, where a petitioner files liquidation proceedings before court, and the court may grant interim liquidation and appoint a provisional liquidator, often known as the official receiver. On liquidation order, the official receiver becomes a liquidator unless and until replaced pursuant to section 438(2). The official receiver may convene meetings of creditors and contributories to choose another liquidator. Court may appoint or remove a liquidator if none or inability or cause is shown pursuant to section 416 of the Insolvency Act. Then we have the official receiver may appoint a qualified person as a liquidator in certain cases and notify the court or creditors as required. That is the last angle of or a method of appointing a liquidator in Kenya. Then we have seen another notice known as intended company dissolutions and notice, where this applies to Companies Act that are going to face the strike-off track, where the registrar, we have two angles of doing the same. Registrar initiated strike-off procedure, and then the company initiated procedure, its own motion. We start with the registry or registrar's initiated one. The registrar forms view companies not carrying on business or is not in operation or has major filing defaults, e.g. extended failure to file returns and to provide financial statements pursuant to section 894 of the Company Act. Registrar sends first inquiry letter to the registered office. Then if no response is obtained, registrar sends a second letter warning of gazettement notice if no answer within 1 month. If no satisfactory response, registrar publishes a gazette notice stating that after 3 months the company will be struck off unless cause is shown. Also sends a notice to the company pursuant to section 894. After 3 months, the registrar strikes off and publishes a gazette notice of strike off. On the gazette publication, the company is dissolved. Then the company initiated procedure, directors or majority lodge an application to the registrar. Registrar publishes a gazette notice inviting anyone to show cause why strike off should not happen. Then registrar strike off publishes gazette notice of strike off and date, and on publication the company will be dissolved. Then we also saw another gazette requirement on a insolvent company, what we call as corporate compliance notices. So registrar issues a directive letter or notice to the company at the registered office or to officers or subscribers if no known office or officers requiring compliance or explanation. Company responds by the stated deadline. File missing statutory returns or financial statements or beneficial ownerships filings. Update registered office or directors or show it is still in operation. If ignored, register escalates to gazette intended strike-off dissolution notice under the strike-off provisions, then triggers the statutory waiting period and objection period. If still not remedied, the register proceed to strike-off and dissolution per the gazette process. So still pursuant to the gazette notice that was published on 8th May 2026, we also saw a change of name gazettement. What are the practical procedural steps of doing a change of name in Kenya, and what are the documents required when it comes to this procedure? So number one, we start with an adult individual who intends to change his name. So you are the advocate. What will you do? You take client instructions and you confirm a conflict check, confirm the old name, confirm the new name, reason, citizenship, any pending suits or charges and documents to be updated. Then prepare the deed poll. This is the instrument of change of name, and have it executed by the client, commonly signed before an advocate or commissioner for oath and witnessed. Then gazettement route, lodge the deed poll and any required supporting documents for publication of a change of name notice in the Kenya Gazette through the Kenya government printer process used in practice. Then for post gazette updates, each is its own mini process where you use the gazette notice plus deed poll to update sequentially. A person can go to the National ID Registry or Immigration Center to update their record, KRA update their record, banks follow their process, NHIF or SHA follow your process, and or NSSF. Then land registry where applicable, academic documents, you follow due procedures. Keep an evidence pack of everything that you are doing. Always, as the advocate, keep a copy of every document that you used in the change of name procedure, because at any given time you can be called as a witness if he is a fugitive who was attempting to flee the country. Then B, what if it is a minor who wants to change a name or correct a name? Assess if it is a correction versus a change, whether it's a spelling error or substantive identity or parentage. 2. Apply to Department of Civil Registration for correction or reissue where administratively allowed. Attach supporting evidence. Then, if disputed or it is complex, you must involve the parent. File in court for appropriate orders. Courts have granted rectification orders on proof. Okay, if a child is above 5 years in Kenya, the Huduma centers will not allow a change of name without the consent of the biological parents. Okay, because it is illegal for a person to name a child and yet a biological parent is alive. Okay, so those are the recent developments of the law. Draft instruments that you will use. How do you draft a deed poll for the individual? This is the structure. You have the title deed poll. By this deed poll made on this date, I, full current name of PO Box in the Republic of Kenya, holder of national ID or passport number, do hereby make and declare as follows. 1. I am the same person formerly known as full current name. I absolutely and entirely renounce, relinquish, and abandon the use of my former name. You state the full former name. Then I assume, adapt, and determine to take and use from the date hereof the name, full new name, in substitution for my former name. I shall at all times hereafter, in all records, deeds, documents, and dealings, use and sign the name, insert the full name as my name. I authorize and request all persons and authorities to designate, describe, and address me by the name that you want to insert. In witness whereof I have hereunto set my hand the day and year first above written, full current name, in the presence of an advocate. It is mandatory, or a commissioner of oaths, witness details thereof. Then it has an affidavit in support. This is not mandatory, but it is optional. Where you swear that the averments that you have made are correct and you appear before a commissioner for oaths. Lastly, we have new bills and acts being published this year, where we have the Gazette also published several legislative supplements, including bills. The bills that have been published, we have the Special Economic Zones Amendment Bill of 2026, the Microfinance Bill of 2026, the Medical Practitioners and Dentists Amendment Bill of 2026, and the new acts that have come into play as per today. We have the National Infrastructure Fund 2026 and the Judges Retirement Benefits Act of 2026. So these proposed laws and are newly enacted statutes could have significant implications for investment, healthcare regulation, and infrastructure funding, and the judicial welfare in the country. Legal education sector reforms, a call for transformative action. This was also a publication that was released by the Kenya School of Law after the legal reforms webinar that was conducted in Kenya. So from this publication, we can say that the Kenya School of Law has formed various mergers or MOUs with Competition Authority of Kenya. Another key takeaway is that they noted challenges affecting students where they have inadequate legal education training in universities. Some universities were not teaching the same modules that are being taught in the Kenya School of Law. Then inadequate time to cover the course contents. So students expressed the fears that having to sit for 9 units, extensive 9 units under a shorter period, they were recommending for students to be sitting for 2 years so that they have one-on-one engagements with the lecturers. Okay, those were just recommendations. Then significant legal and regulatory developments for the year, for the period October to November 2024. So generally, I decided to extract any landmark decision that fell or in the period of October to November 2024, because anything can be asked therefrom, and this marks the conclusion of this webinar. Firstly, we have the ODPP complaint number 740 of 2024, where it is known as Louis Jane Joki versus Spartan Vacations Limited. This decision reinforces the necessity for businesses to seek and obtain explicit consent from data subjects before processing personal data for marketing purposes. Further, any data processor or controller should clearly inform individuals for marketing purposes uh, for purposes of data collection, especially when it involves direct marketing. Failure to disclose this information is likely to invite legal implications. Then lastly, we have Kagai versus Kenga Equatorial Hotels Limited, a decision that was passed in 2024, a landmark decision when it comes to the employment sector, where employers cannot introduce reasons for termination after the fact. Where the reasons are not included in the termination letter, they cannot be used in court to justify the dismissal. The decision reinforces the necessity for both substantive and procedural fairness when terminating employment. This takes a shift where employers were initially introducing new reasons for termination when the matter was filed by an employee in court to justify their reasons. So the court will be bound by whatever the reasons that were outlined in the termination letter. Thank you for your attendance and have a good weekend. Thanks.